You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, shall be heard. God save these United States, great state of Florida, this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. First case on our docket today is the state of Florida versus Fitzpatrick. You may begin.
May it please this honorable court. Your honors, my name is Katherine Blanco. I represent the appellant in this case because this is a state appeal from a trial court order granting post-conviction relief on the basis of a claim of ineffective assistance at the guilt phase and the penalty phase. Before I get into my argument, I would just like to briefly summarize what defense counsel was faced with at the time he was representing Mr. Fitzpatrick. In this particular case, the defendant, Michael Fitzpatrick, was the last person seen alive with the victim, Laura Romines, 3 hours before she was discovered on the site.
The standard in this case is not whether there's some evidence as to whether Mr. Fitzpatrick was around the scene. I agree with you. I mean, the truck and all those things. Let's go into. I mean, this is a pretty significant case in my mind, and you know how juries react to DNA evidence and that kind of thing, and the questions with regard to whether the nurse was really qualified and whether there should have been objections. No other witness testified. Let's go really to the meat of this.
Certainly, Your Honor. If I may, with respect to the grounds that the trial court granted post-conviction relief on, I've addressed them in the sequence that they were addressed in the trial court's order in our brief, and in our reply brief we've addressed CCR's same sequence, and so we have responded there. With respect to the first issue that the trial court granted relief on, that would be the claim with respect to failing to consult experts in serology or DNA to refute the timing of the sex with the victim. Again, the victim was discovered on the side of the road. She has a quantity of fluid in her vagina that is taken at 8 a.m. after she comes out of surgery. She's discovered about 3:30 in the morning. By the time she's out of surgery, that sample is taken during the SAVE exam, and that is tested, and it proves to be Michael Fitzpatrick's DNA. Post-conviction testing also shows that it is Michael Fitzpatrick's DNA and no other male DNA on the undergarment that was found pulled up under her breast.
Okay, so it's established that his sperm was in her.
It is established, Your Honor.
Okay, but there's a question here about the timing of when that was deposited.
Yes.
And which is central to the case, or central to the state's theory of what happened. And in the evidentiary hearing, there's a lot of doubt, it seems to me, to have been cast on what the jury was presented with respect to that timing. And I'm having trouble understanding why, in a case like this, where that sperm and the circumstances, all the circumstances surrounding that, were so central to the state's theory and so important to the defense of the case, that the defense attorney here would not have done more to try to challenge what the state was claiming about that those facts.
What defense counsel did, Your Honor, was consult two experts, Dr. Littman and Dr. Fiegel. And Dr. Fiegel, who was ME and also a lawyer, explained to him that the problem he would have would be gravity. And that is that with respect to the timing of the sexual contact with the victim, gravity, the fluid that was still pooled in her vaginal cavity, would have leaked out. If the timing that the defense theory was, eventually the defendant gives multiple stories. He said, first I didn't know her, then I didn't have anything to do with her, and then I gave her a ride, and then I never saw her after 7:30 at night. And then you have witnesses placing him with her at midnight. She's walking out arm in arm with him at midnight, and she is discovered at 3 a.m. in the morning, 3:30 in the morning, in this horrible state.
Again, you're not going to get any pushback from the court as far as all those facts. I mean, that was laid out. It's in the original opinion. Please respond to Justice Kennedy's question about the importance of this DNA.
Certainly, Your Honor, and I perceive Justice Kennedy's question also, Your Honor, as to what defense counsel did with respect to investigating the timing on the sexual battery, which was the defense theory. When the defendant finally said, oh, well, okay, I had sex with her, but it was the day before. Now, of course, he couldn't deny having sex with her because it's his semen in her vagina. So what he says, eventually his fourth or fifth story down the line is, okay, yes, I had sex with her, but it was the day before. So that's the defense theory, and it was between 9 a.m. and noon. So to respond to that, the state introduces evidence, not only the condition that this victim is found in, the quantity of fluid that's in her vagina, the fact that it is Fitzpatrick's DNA and only Fitzpatrick's DNA there. The defense attorney at the time of trial goes to USF Library. He pulls articles on the persistence of sperm. He questions expert witnesses
but the fact is that a defense attorney doing his own medical research, I mean, that's like doing surgery on himself. I mean, it seems to me on that sort of question, you've got to have an expert who has the expertise to understand what the literature says and interpret it. And for a lawyer to be interpreting the medical literature just seems to me to be just very unusual.
Well, Your Honor, I would question that this court would make a bright line rule that an expert is necessary in every case.
Well, I'm not saying, and again, I would certainly agree with you that there would not be, we would not want to have a bright line rule about an expert in every case. But in a case like this, where the best defense he had was, which they end up with, is that he had sex earlier in the day, or the prior day, to go in without any kind of expert help trying to establish that point seems to be going to this very serious fight unarmed.
Your
I mean,
Honor,
when I say fight, the trial.
certainly, Your Honor. And the defense was twofold. It's number one, the defendant says he had sex with her the day before, and somebody else did it. He denies being with her any time after earlier in the evening when he drops her off at the motel.
Well,
he denies.
The question for us is not whether we think he did this, okay? I mean, we might think that you put it all together, he probably did it. But the question is whether our confidence in the jury's verdict is undermined by the way counsel performed. And so, again, I understand. There's a lot that points to the defendant here. I understand that. And other than this just the DNA. But again, given the standards we've got to operate with, that's not really whether we might conclude that on balance we think he did it is not. That's kind of irrelevant to the analysis we have to go through, isn't it?
Well, what you're looking at is the Strickland standard, and whether there was deficient performance and resulting prejudice. Whether,
and what is our standard of
confidence
review?
In the
what is our standard of review?
The standard of review, when you are evaluating claims that come to this court after an evidentiary hearing, factual findings of the trial court that are supported by competent substantial evidence, and again, as to the are accepted, it is a de novo review when you get to the mixed questions of law and fact, and which is the ultimate Strickland
That's where
issue.
Justice Kennedy's going, is that if there's competent substantial evidence to support what Judge Tepper found factually here, then that's what we're working with. And again, you keep going back. Please understand, you're going to need more than there's a lot pointing to him, because I agree with you, and it's all laid out in the original opinion. But this prosecutor stuffed it right down his throat when he talked about the undergarments pulled up, and there's no semen on those. And I mean, yes, there was, according to now what we know. And it couldn't have been that time, because motility and all of these concepts of how the sperm moves and how it dies. Well, that's all wrong, and that was shoved down their throat during closing argument. So that's what you're really going to need to help us look to, as to why is there not competent substantial evidence to support what this trial judge determined in the evidence that's come out now. Again, not saying this is a JOA. That's not what we're saying. We're saying this with the standard we have.
If you look at the fact findings of the trial court in the post-conviction order, you have the fact finding, number one, that the right-hand fingernail scrapings of the victim taken at the time of the autopsy were not tested. That's incorrect. It's unsupported by the record. As a matter of fact, CCR doesn't dispute, nor would they dispute, the fact that those right-hand fingernail clippings were tested by Dr. Ragsdale. Indeed, that was an issue that was litigated at the time of trial. It was raised on direct appeal. So the trial court in the post-conviction order makes a finding that the right-hand fingernail clippings, the autopsy clippings, were not tested. They were, at the time of trial, they were tested. At the time of trial, defense counsel made an argument that pointed to a third-party contributor. That issue was raised on direct appeal. Now, the only difference between the testing that was done at the time of trial and in post-conviction is you have it identified as a single source contributor rather than a mixture with a third party.
Can we just go back to the sperm issue? Because
Certainly.
You said something in response to a question that Justice Kennedy asked, which was you don't want this court to adopt a bright-line rule that a defense attorney always needs an expert. And we agree with that in many, many cases, and most of the time, or almost all the time, you're on the other side defending or as the appellee, because we don't have bright-line rules. We look at the facts of this case. And frankly, reading, and I'm mainly focusing on the issue of the sperm and the fact that there was sperm found on the underpants, whereas a big deal was made by the state over and over again in closing about how important that was on the timing issue. And the other thing that I found to be, to me, I don't know if shocking is the word, but pretty incredible when you say that this defense lawyer went and did his research at the USF library, is that he didn't understand, and apparently still didn't understand by the time of post-conviction, something that, at least according to the experts that Judge Tepper then accepted, and that seems pretty important to me, the difference between motility and sperm that have just a tail. And therefore, because we're such a science-based, with CI, whatever it is, what are they, CSI, when you've got science and you've got the state relying on science, and you've got a defense lawyer whose science consists of a couple of quick conversations with some experts and then doing his own research, I can't come to any other conclusion based on the trial court's findings that he was deficient in his performance. So now I think the stronger issue is why our confidence shouldn't be undermined when the basis for the defense was timing, and all of this goes to, and the state relied on the sperm to come up with timing. So I understand some issues. There may be some other weaker findings of the trial court about some of the other scientific issues. But if you could get back to how this issue on the sperm doesn't really undercut the state's case and refuting the defense case, and how the performance of the defense lawyer would be a performance that we'd say meets acceptable Sixth Amendment standards.
Thank you, Your Honor. Justice Perianti, as I understand your question, you want me to address primarily the underwear and the motility issue. Is that correct?
Well, you said, but because what you were saying to Justice Kennedy was that we shouldn't have a bright line rule that you need an expert, and I think we all agree with that.
We agree. The United States Supreme Court certainly has set that out.
It's not an issue that when you come to a case of guilt in a death case where science is the most important thing being relied on by the state, that you don't even invest the time to understand through experts whether the science that the state has developed is refutable, and that you don't even know how to cross-examine the nurse who has some findings that some very qualified experts completely refute. So I'd say that, do you agree that we don't have to affirm the trial court? We don't have to say that this means that a defendant always has to have an expert when there is scientific evidence that's going to nail their client, that it's not per se ineffective. But in this case, under these circumstances, it would have behooved this defense lawyer to have known what the science was. So just answer that question, and then how does that not undermine our confidence as to just the issue regarding the sperm?
That it would have benefited defense counsel to know that there was additional testing available that might have detected semen on the undergarments, and that the question of motile versus non-motile was an issue of intact versus sperm with heads and tails. There has never been a motility test conducted in this. It's impossible to do now. The experts that testify in post-conviction testify on the basis of the intact sperm versus heads with tails. So the conclusions they reach are not based on motility. The term motility refers to those that are actually swimming in wet slide. Usually,
but wasn't that used by the it wasn't? That's the whole problem. That they used that.
No, the terminology was used by the prosecutor originally to say, this is what I'm talking about. If a sperm has a head and tail, it would be motile. And the expert agrees with that. It would be motile with a head and tail. So you've got some with heads, some in many fields with heads, some in many fields with tails.
I'll make sure I'm understanding here. Are you saying that if it has a head and tail, it's necessarily going to be motile?
No, it
has to have a tail to be motile.
Correct.
We understand that.
Correct.
But there can be non-motile sperm that still has the tail, right?
Correct.
Okay.
Correct. It's and the way the prosecutor was using that term, so we have some with heads and some with tails, and many with tails, and tails are very fragile, so they will drop off after a certain point in time. So the experts that have come in post-conviction are saying, relying on the same the same study that was done on the heads and tails to extend that timeline. But that timeline was already extended by admissions of the state's experts at the time of trial. They admitted, look, it's not an exact science. You normally would see the tails falling off after a period of 12 hours. Putting the outer limit, Dr. McMahon, who the trial court even criticizes the state for calling her a doctor, but she's a PhD and earned the right to be called that, put the outer timeline as 15 hours from the time that the sperm samples were recovered, and that would have put it back the day before by 5 p.m. And in post-conviction, the experts relying on the identical tests that were conducted and articles primarily by Allard and Collins concerning deceased victims, where you're extracting them post-mortem in an attempt to extend the timeline beyond a 16-hour period. So we still, in post-conviction, you have Dr. Ragsdale, who puts the time back of 8 hours from the time that she was found. And then you have the defense experts, Dr. Spitz and Dr. Johnson, relying on other articles saying that, no, you can extend that timeline. But that timeline has to be coupled with the defendant's claim that some other person did it. And this defendant is the one that is with the victim at midnight. This victim is again found...
Some other person did what?
I beg your pardon?
Some other person did what?
Some other person raped this victim, stabbed this victim.
Wait. Now that gets a little complicated, because there can be she might have. It's conceivable that she had sex with the defendant earlier in the day, according to his theory. I mean, his theory is that he had sex with her, but he didn't murder her. Now, it is not necessarily the case that whoever murdered her also raped her. And furthermore, it's not the case that even if she was raped, that person would have necessarily left sperm. That can happen. So, I mean, all of that involves a lot of different questions and assuming things that I don't know that we are justified in assuming.
Well, it was presented to the jury. Certainly the question to the jury was that she would have had consensual sex with the defendant without a prophylactic, taking his version the day before. Somebody else attacked her, stabbed her, pulled her undergarment. A woman is not going to pull her own undergarment, her underwear, up under her breasts and be bleeding and left in this condition, that the semen linking the defendant as the source, or the defendant's DNA linked as the source of the DNA in her vagina, not being displaced at all, and no one else's is found
again,
there.
I mean, I think you've got a strong argument that there was a sexual crime here, but to rely on the fact that if there was a sexual crime, the person who perpetrated that must have left sperm there. I just think, I mean, maybe, but maybe not. I mean, we know there are sexual crimes that are committed where the perpetrator does not leave sperm. Isn't that correct?
Oh, that's possible. That is
possible.
Well,
it's not just possible, it happens.
Certainly there are those types, where there are protection taken, where the evidence is washed away. In this particular case, the victim was seen the day before being observed with her garments in trash bags, small garbage bags. She is a woman of quite a vagabond lifestyle, apparently. She has been drinking beer. And so a logical inference from that is, if the only time she had sexual contact with this defendant is 9 to 12 the morning before she is found at 3:30 with his semen in her vagina, his DNA in her vagina, nobody else linked to that, he's the last person seen with her, the jury was entitled to reject as unreasonable a suggestion that somebody else did it.
Except she told him that Steve did it, and then she goes into the hospital, and she's under heavy morphine sedation, and there's questions as to when she withdrew that statement. I mean, so this, when you say that from her own lips, she said Steve. So, the problem is you can take bits and pieces here. And again, I think the state has a very strong case, even with where they are now. But you're not talking to the standards this morning with us, and that's what we're hoping that you would do. And that is, you're trying to tell us there's conflicting evidence, and that's not the standard.
Your Honor, the standard, under Strickland, you're looking at the totality. Are we looking at, has confidence been undermined? Was defense counsel's performance deficient, and was confidence undermined as a result of prejudice that the defense has alleged in this case? And the state's argument, as extensively set out in our initial brief and answer brief, is that as to the guilt phase, there has been no fair showing of both deficient performance and resulting prejudice. And the penalty phase, I'm afraid I've run out of time. I don't have time to address this morning. If the court has any questions, in case Ms. Perinetti wants to respond to it, but as to the penalty phase, the defendant was emphatic. He has never rebutted that he was adamant that no mitigation would be presented.
You've well exceeded your time. If you could conclude.
Okay. Thank you, Your Honors. I would ask the court to reverse the trial court's order granting guilt and penalty phase release on the basis of Strickland. Thank you, Your Honors.
Good morning. I'm Maria Perinetti with CCRC Middle, and I represent Michael Fitzpatrick. As this court has recognized, science was central to the state's case. However, I'd like to respond to some statements that my opposing counsel has made. Several times they referred to the alleged fact that Mr. Fitzpatrick was the last person seen with the victim alive at 12 o'clock at night, which was approximately 3.5 hours before she was found on the side of the road. There actually was testimony at trial from Cindy Young, who is a resident at the Sunny Palms Motel. She testified that she saw the victim, Ms. Romines, come to the Sunny Palms Motel sometime around 3 a.m., which was about a half hour before she was found. She said that she saw her come to the hotel in a car that she recognized as a car belonging to a Mr. A.J. Howard. She saw the victim get out of the car, knock on the door of the manager, and get back into the car. So there was testimony that somebody saw the victim with somebody other than Mr. Fitzpatrick after 12 o'clock. That's a 3.5 hour time span between when the last person somebody allegedly saw Mr. Fitzpatrick with the victim and when she was found. And sadly, as my opposing counsel has stated, the victim in this case, Ms. Romines, lived somewhat of a vagabond lifestyle. In the 24-hour period that we're looking at, she went from living with a man named Steve Kirk, who she had only known for approximately 2 weeks. She was living with him because her boyfriend beat her up. She allegedly had sex with Mr. Fitzpatrick. Then she went to the Sunny Palms Motel, where she met some women who introduced her to a man named A.J. Howard, a man who had young women living in his house with him. She went and stayed with A.J. Howard, and then allegedly Mr. Fitzpatrick came and picked her up at this house. So in the course of just a 24-hour period, she's going from one stranger to another. It's not inconceivable that she would have, between midnight and 3:30 in the morning, that she would have come into contact with another person who could have committed this murder upon her. There was other exculpatory evidence, as the court pointed out.
As far as that goes, are you pointing to another suspect? Is there evidence developed of another suspect?
And there were, at trial, there were two potential other suspects. One was, the most obvious suspect was Steve from Water's Edge. And the man that she was living with, whose apartment she was kicked out of the day before she was found, his name was Steve, and he lived at Water's Edge Apartments. Mr. Fitzpatrick also lived at Water's Edge Apartments.
Steve is Steve Kirk.
Steve Kirk, yes.
And that's when she said out of her mouth, she said Steve.
She did. She said to 4 separate people who were at the scene when she was found that Steve from Water's Edge did this to her.
But does Steve have a pretty good alibi that he couldn't have done it?
The state presented an alibi, basically an alibi defense for Steve Kirk at Mr. Fitzpatrick's trial. Interestingly, the victim was found...
let's just put it, the state doesn't have an interest in getting your client over Steve Kirk. So was there any other than her saying that? Was there any evidence that pointed to Steve Kirk as a potential suspect?
I believe there was. Steve Kirk was a security guard at the Motel 6, and that's how he met Ms. Romines in the first place. His alibi for the night of the offense was that he was working at the Motel 6, and the state brought in several witnesses who testified that they saw him throughout the night. Interestingly, around 3:30 to 4 o'clock in the morning, which was right around the time when the victim was found, one of the hotel guests called in to hotel security that there was somebody that was trying to break into her room. And she testified at trial that it took a half hour for Mr. Kirk to respond. Since he was a security guard at Motel 6, I would imagine it's not very good.
Is that new evidence that you found, or was that at trial?
That was presented at trial.
So did you develop in post-conviction anything that the defense lawyer should have developed regarding another suspect, either Steve Kirk?
No, Your Honor. I think that why that becomes more important now in post-conviction is that the jury did hear this evidence about Steve Kirk. However, they're left with scientific evidence that, as the state argued in its closing argument, that the scientific evidence that they presented proved that it was physically and scientifically impossible for there to have been anyone else involved with Mr. Fitzpatrick. So when the jury looks at the fact that the victim said Steve did it, that Steve's alibi is shaky, that Cindy Young saw the victim getting into and out of a car belonging to A.J. Howard, that A.J. Howard was seen the next morning burning some items in his yard, and that was presented at trial also. Also, Fitzpatrick's girlfriend presented an alibi for him at trial. However, when the jury looks at the state's evidence that's completely unrebutted by the defense, they're left with the state's argument that it's physically and scientifically impossible for there to have been anybody else involved. So your argument really here is that with the state so strongly relying on scientific evidence, which you believe you have shown based on deficient performance could have been severely undermined, the idea that the linchpin of the scientific evidence was such a basis for the state's case that for us to just say, well, they still would have found him guilty without the scientific evidence just is not the standard we should apply. Correct. It's a reasonable probability of a different outcome, and if you just look at the state's rebuttal closing argument, where they urge the jury to forget it all.
Well, it's really, even though we use a reasonable, when we've used it this morning, it's undermining confidence. And what's important about that, which means, because I think if it was just, well, is it more likely than not of a different result, we might go someplace else, is that my concern is that the state really did rely on this evidence so strongly for its case, as you said, that with it not being rebutted, and the jury has no other choice but to convict, it seems to me, in the first trial. And I guess that's your major argument. But so as far as any of the other suspects, those two people, that there was no other evidence that this defense lawyer should or could have uncovered that would have led strength to those suspects, or better have given Fitzpatrick an alibi? Nothing like that? No,
not that was presented at post-conviction. There were 3 additional Steves other than Steve Kirk. There were 3 additional Steves at the Water's Edge Apartments. One who I believe there was testimony at trial, he broke his contract and left quite suddenly, and those were never investigated by law enforcement. So the other possible suspect, I might add, is whoever's DNA is under the victim's fingernails. And in post-conviction, we learned that this wasn't just DNA that could have been from casual contact. This was an actual visible piece of human tissue. This was a piece of skin. It's not something that you get just from touching somebody or sitting next to somebody. This is significant contact that the victim would have had with this person.
And what happened? Did you have that tested?
We did. At trial, prior to trial in 1997, it was tested using PCR DNA testing. We had it tested using STR DNA testing, which was available in 1999. FDLE started doing STR testing. However, defense counsel never requested additional testing. So As opposed to the testing that was done prior to trial, they found a single marker. They could not exclude Mr. Fitzpatrick. They could not exclude Mr. Kirk. We were able to obtain a full profile of a male, an unknown male. And we and
you definitely had Mr. Fitzpatrick excluded.
Right. Mr. Fitzpatrick was excluded. Mr. Kirk was excluded. And also Dwayne Mercer, who was one of the first responders, who there was testimony at trial that she scratched Mr. Mercer's arm in this court in the direct appeal opinion, stated that it was likely that the DNA that was under the victim's fingernails might have come from Mr. Mercer. Mr. Mercer gave a DNA sample, and he was excluded as well.
So, how did the state use that? How did they use it, or did they not use it at trial?
They didn't use it at trial. Defense counsel tried to introduce it. Defense counsel testified at post-conviction that this was his hook, that he thought that this was going to be a big part of his defense, and he wasn't able to introduce it at trial.
And why wasn't he able to introduce it?
These were the fingernail scrapings and clippings from the autopsy. He mistakenly believed that they were from the SAVE exam, and he didn't properly authenticate them, so he wasn't able to get them in.
If you really want to look at some basic deficiency, that has to be at the top of because there's no question that this could be introduced into evidence through an expert witness now.
Yes.
And you would then exclude, as somebody, if she has defensive action, you exclude him as being the person that she was clawing at the time that she was fighting for her life.
Right. It could not have been Mr. Fitzpatrick. And also especially when you look at the testimony regarding the motel sperm versus the sperm with tails, the timing is so significant in this case. And as opposed to the testimony at trial by Dr. McMahon, who she admitted that she wasn't, that she had not, she quote, made a study of motile sperm. She was familiar with it, but she had not made a study of it, versus our experts, Dr. Spitz and Dr. Johnson, who testified that the amount of sperm that had already lost their tails was more consistent with Mr. Fitzpatrick's story than it was with the possibility that he was with the victim, and it was deposited closer to the time that she was found.
Could you just, on the deficiency, because, we in many cases, we decide a case on either there is no deficiency. This defense lawyer had been with the public defender's office, and had he just left?
This was his first capital case on his own.
And could you give a picture of what he did or didn't do? Because it's somewhat startling if you read the full order of Judge Tepper. And this is a case, by the way, where we've got, 5 days of evidentiary hearing, and this spanned a very long time, which, by the way, if this defendant is potentially innocent, seems like we should be speeding this case along, not dragging it out. So give us the quick picture of what the defense lawyer failed to do and what his explanation is.
He failed to hire a single expert, and there was some testimony. I should point out also that the trial court specifically found that the defense attorney was not reliable.
Not reliable in what he was able to...
That she was not able to rely on his
because
testimony.
He didn't have a single note?
He didn't keep notes. He didn't keep time logs. His testimony was very vague. There was a lot of I don't remember. I don't believe. I can't swear to it. So her finding that he was not reliable is definitely supported by competent and substantial evidence. But even if you look at what he did say about these alleged conversations he had with two experts, the DNA expert, opposing counsel, stated that it was a Dr. Littman. He actually said it was a male DNA expert. He couldn't remember what his name was. And then he had talked to him about the sperm being found in the victim, and he was told that, well, if you tested it again, then it would just match again. Well, we're not disputing that Mr. Fitzpatrick's sperm was found inside of the victim. He actually admitted to having sex with her. So that really, I think that
he didn't exactly admit the first timer. I mean, this is not like we've got this angel over here that just is most likely wrongly accused. I mean, so let's just...
Right, and I should point out that when he was interviewed the first time, his girlfriend was standing right outside the room. So just the fact that he did not tell the truth the first time, I think, isn't in and of itself enough to convict him. So I'm sorry.
What else? So he didn't remember. So you question whether he actually really ever talked to an expert.
But even if he did, so even if you were to say what he said at face value, these were brief conversations. The conversation with Dr. Fiegel was he said it was a half hour over lunch. In a capital case where the state is relying on scientific evidence, where your client is maintaining his innocence, there's no eyewitness. This is really based on scientific evidence. That he never sent discovery to these experts. He didn't retain them. He had a brief conversation with them. Dr. Fiegel, who was the medical examiner, he didn't show him pictures of the victim's injuries. How was he to assess whether was this a cigarette burn, was this a bite mark, or a puncture
Would you
wound?
say this, because most of the time we talk about experts as far as do you need an expert on mental mitigation, but in terms of a capital case where the strength of the state's case is DNA, isn't it, it's not per se deficient performance, but the fact in this day and age to not have the tools to either cross-examine or present your own expert when the scientific evidence is there, that's pretty close to deficient performance. But I think what gets me is that he said, well, how I prepared is I went to the USF library and I did some of my own research, because it's just, when we're talking about life or death, it seemed pretty incredible that that's how he would prepare.
I agree, and this is difficult stuff. The articles, some of the articles that our experts relied on were introduced as court exhibits, and I believe they're in the record, and they're very difficult to understand. And I think you need to be an expert to understand. The trial attorney he testified at the evidentiary hearing that he may have confused sperm with tails with motile sperm. I don't even think that he realized that there was a difference, and he didn't even know enough to ask.
But is this something out of character? This is somebody was trying or defending capital cases for the public defender's office?
Yes.
So it's not like we just have to sort of wait and see whether this lawyer, just because he was just out on his own at that time and sort of wanted to make money, or what would have motivated him to say these things that sounds professionally pretty incredible, actually. Mm-hmm. We don't know. Whether he was going through a difficult time in his life or what.
And he represented Mr. Fitzpatrick over the course of 4 years. So in 4 years, his guilt phase preparation.
Do we know how many hours he spent over the course of 4 years?
We don't, because he never billed for this. He was a court-appointed attorney, but he said
so
he
was
never
it
billed.
a set fee? Was that it?
No, he could have billed hourly, but he did not keep track of his time. He did not bill.
So how much what did he report? What did he receive?
He did not get paid for this case. He said that because he lost, he felt that he did not want to bill for the case. So he didn't get paid for the case. And again, he didn't, even though Mr. Fitzpatrick was indigent, he never asked for money for experts. He had an investigator that served some subpoenas. That was basically the extent of her
did his investigation start while he was with the public defender's office and you went on the case with him?
No, Mr. Fitzpatrick called him when he was at the public defender's office. There was several months between when police started questioning Mr. Fitzpatrick and when he was actually arrested. So he did speak with him while he was at the public defender's office. He advised Mr. Fitzpatrick not to give DNA, but he didn't take the case until I believe it was February of 1997, which was about 2 months after he left the public defender's office.
So he was a court-appointed, he wasn't hired first by the defendant.
He was a court-appointed attorney.
While he was with the public defender, in reading the trial judge's order, he says in here that he enjoyed a respectable reputation while he was with the public defender's office. Mm-hmm. While he was with the public defender, did he try a lot of these homicide cases, death cases?
Yes, many. And he wasn't able to give an exact number, but he had, over many years, he had tried many homicide cases. And as the trial court stated, he really should have known better about keeping records and notes and things like that.
Are you familiar with his performance in the public defenders? Was he in the habit back then of retaining experts and things like that in these type of cases?
There's nothing in the record about that.
Because, it's one thing when you're with the public defender's office, the office is budgeted where you have in-house people to help you with these cases. When you're out on your own, you got to go begging trial courts to give you a nickel and a dime to hire people here and there. So you may become accustomed, institutionalized in a sense, to getting these things by just asking the boss to approve it, as opposed to having to ask a judge. I'm just wondering if that's the case here, that he just left the public defender's office and he was shocked at what he had to do to get what he got automatically.
It may have been, but he didn't try. I don't want to say he never tried. He didn't try until after the verdict already came in, prior to the Spencer hearing. That's when he asked for experts. And at that point, the state argued, it's too late. It's procedurally barred at this time. We already tried the case. And if this is going to be an issue for post-conviction, then so be it.
But I think what Justice Labarge is saying, and I thought there was something in Judge Tepper's order about this transition, that it was, he was reluctant to ask. But the bottom line is, he never even tried. He didn't try to ask for a retention of an expert on DNA. So it wasn't like he tried and he didn't, or he got one and he wanted to get a second one. He didn't even ask for the first.
Right. And this is
in the Sixth. By the way, this is the Sixth Circuit. This trial was
correct.
Yes,
it was in Pasco County.
Okay.
And he didn't. And this is a lawyer. He did file motions. It's not like he was afraid to file motions. And if he had asked for an expert and the motion had been denied, then this court would be on direct appeal, and this court could have determined whether that was proper or not. But he never even asked for an expert. He never asked for co-counsel. In essence, he wanted to do this all on his own. And I see that my time is just about up. I would ask that the trial court's findings of prejudicial ineffective assistance of counsel in guilt phase and penalty phase, that they're supported by competent and substantial evidence, and we would ask...
you would agree, if we find and we agree on guilt, we don't really need to go over the penalty phase and whether the waiver of mitigation, we would just reverse.
Yes, and penalty phase would, in essence, become a moot point.
Thank you for your arguments.
Thank
you.
The
next case for the day is Diaz versus State of Florida.
Good morning.
Good morning.
If it may please the court, my name is Roseanne Eert, Assistant CCRC. I'm here this morning on behalf of Juel Diaz. This morning, I would like to focus primarily on Argument 2, the deficient performance and prejudice as it relates to the imposition of the death sentence. But before I sit down, I would like to spend just a few minutes on the juror misconduct issue. This is a case where on direct appeal, 3 members of this court would have reversed due to the fact that HAC was applied by the trial court and was stricken on direct appeal. And 3 members of this court found that the state could not establish harmless error beyond a reasonable doubt. So with respect to prejudice, the jury did hear about the domestic violence and the cycle of violence that went on in the Diaz home. They heard a lot of information about the home life of Juel Diaz from the time that he was a teenager until young adulthood. What they never heard was what happened with him from birth on, that Mr. Diaz was born into a Mexican-American subculture or underclass at the border of the Rio Grande River in Texas to a very young mother. He came from a family of migrant farm workers, and he was taken to the fields at a very young age. At some point, he moved, probably around the age of 5 or 6, to the Fort Myers area. And what the jury did not hear was how his experiences from birth until the time that he was a young teenager, whether it be the exposure to poverty, his illness as a baby, the exposure to the chronic and what Professor Griffith referred to as structural violence. He was exposed to violence not just in the home, but in the neighborhood. He was bullied in the neighborhood. It was a violent neighborhood. There was testimony that he saw dead bodies in the street. I mean, this is how violent the neighborhood was. And he was exposed to violence as a preteen when he was working with his mother in the as a farm laborer, that there were adult men who were fighting, drinking, going to prostitutes. And so all of these risk factors were present for the development of cognitive deficits. And what the trial attorney never heard was how his experience, the deprivation, impacted not just his young developing brain from birth onto age 6, but how it colored his perception, and how he ended up at the place where he ended up at the Shaw home and committed these murders. I think the trial court made some specific errors when it came to the finding of deficient performance. First, the trial court and the state really ignored the trifecta of cases that talks about what constitutes a reasonable investigation. We know that a reasonable investigation includes a complete exploration of the client's life, not just from birth, but really from conception.
How old was this defendant at the time of the crime?
He was 24 years old.
And had he had any history of prior violent felonies?
There were no prior violent felonies. The prior violent felony that was applied in this case was actually the contemporaneous felony, and Your Honor, in the dissenting opinion on direct appeal, recognized that under Hess that is not as significant of a prior violent felony. The trial court found no significant history of prior criminal activity, although what the jury heard was that Juel Diaz did have a history of domestic violence, that he, in fact, not only was violent toward Lissa Shaw, but he was violent toward his other girlfriends.
But what you're saying was, tell me again, what was there was a history of domestic violence in his family?
Yes.
That was not heard by the jury?
That was heard.
I'm having trouble understanding what part that would have made such a difference, to the jury. I mean, it's striking HAC. I mean, again, I said what I said in my dissent on the sentence. But what part was so that if it was discovered really would have changed the picture of the penalty phase? Because you have anyway. There's no question that this was a distraught person who was, thinking he was going to kill himself after this. He was, he waited till the police came. So the facts are the facts. What is it that you've reported that would so change the picture of the mitigation in the case? I'm still not sure I understand the additional mitigation.
The humanization of Juel Diaz in terms of the cultural relevance of his life. I mean, they saw a young man who was raised in an environment where the dad beat the mother, and Minerva Diaz testified that her father beat their mother, and her brothers beat their girlfriends, and that Juel did the same. No one, though, talked to the jury about what that really means. And as a matter of fact, Neil Potter, the state tried to get him to say, well, isn't that kind of mitigating this cycle of violence? Because it came out at the penalty phase that he had been violent, that this wasn't an isolated incident, that he had been violent. But once that came out to the jury, that he had this history of violence toward his girlfriends, they needed to talk about the cycle of violence. And you can't just do that in the vacuum. No one ever did that. The state argued in the brief that, Dr. Keown talked about that, but that was kind of like a secret mitigation. The jury was never told in the penalty phase.
I'm hearing what you're saying, and I understand that you could put on a better case of mitigation than was put on at trial. Okay, we'll stipulate to that. But again, that's not the test that we have to look at, not whether it would be possible to find more and maybe add to what was there. The threshold question here is whether the counsel was deficient. And if we don't get past that, if we don't find that what the counsel did was so inadequate that effectively wasn't functioning as counsel should, then the rest of it becomes kind of irrelevant.
Right, and the thing is we didn't, I think that's a huge point that the trial court made. It's not just that in post-conviction we did more or better. We actually took what was there and what was in front of the trial attorneys, and they didn't bother to look at it. Dr. Crow, when he evaluated Juel Diaz, wrote in his report that Juel Diaz had a history of farm work, that he had a history of menial labor, and that his IQ was only 86. 86 is a low IQ. The jury was told that he had average intelligence. So that information was right in front of their faces. We didn't come out later and do better or more. The trial attorney didn't even have Dr. Crow's report in his file, and his entire file's in the record. The guilt phase attorney had it, but the penalty phase attorney never even looked at that.
But it seems like what you're saying is that they should have done a better job with this. And I can, to really link in the cycle of violence. But I'm still going back to, and listen, I'm sympathetic to the situation, but still we got to follow the standards that we set forth for deficient performance. What do you point to as the most, you heard the last case where it was a state appeal, with some pretty egregious failures. What here is you look at it and say, well, any reasonable attorney would have done this.
Every lawyer is required to look at their client's life from birth until age 6, or actually from conception until age 6, because we know about how the brain develops. Dr. Dudley talked about how the brain develops. And Dr. Kling, who they had at the time of trial, said that if he had been given jail records, school records, Social Security records, if he had known, not that Juel Diaz worked as a farm, agriculture at age 16, but if he had known that he was in that environment as a toddler and that he later was there as a preteen, he would have recommended a neuropsychological evaluation. There was no neuropsychological evaluation.
Okay, and what happened? Did you have one done?
We did, and the IQ, I recognize that there were some issues with the IQ test, and I think that, his IQ is anywhere between 57 and 86. Let's assume that his IQ is 86 based on the kind of down and dirty IQ test. First, that's still a low IQ, and low IQ in and of itself is a mitigating circumstance. And it's not just that the jury didn't hear that. They heard the opposite. They heard that he's of average intelligence. Now, it's not just IQ. There's also cognitive deficits that color the frontal lobe, which is the executive functioning, that Dr. Dudley tied in. As much as the United States Supreme Court does not require a nexus between the childhood and the crime, but there was a nexus, and the jury never heard that nexus. They heard that, well, he was beaten and he committed this crime, but they never heard the entire picture. But
isn't the problem here that if he had executed the crime against his girlfriend, that, and in a domestic violent way, then you talk about the cycle of violence.
Right.
But here, after he attempted to kill her, he did this thing that was really, he killed the father, and then he talked about he started acting really pretty crazy. So the early life doesn't seem to me to explain that. Did you have an expert that really explained what was going on after he tried to shoot the girlfriend?
Yes, and Dr. Dudley did both, Your Honor. Dr. Dudley talked about how the early life that all of these risk factors impact the way the brain develops. So that never stopped. His brain was already developed.
But it doesn't add. You weren't going to allege the statutory mitigation. Did he?
Dr. Dudley found both statutory mitigators.
Based on, and how? Again, you can sort of say it, but
right, because it wasn't just that he was exposed, and I don't think the domestic violence was the key issue here. I think that was one part. We know that because he was exposed to this poverty, deprivation, had possibly meningitis as a child, although we weren't able to get the records, that all of this impacted it controlled how his brain developed. So now we have a little boy with cognitive deficits who didn't do well in school, who is exposed to this violence, and Dr. Dudley said there was no safe space. His mother herself was very low intelligence, really a beaten down woman who didn't teach him right from wrong. So there was no safe space. There was no loving picture. And it was a structural. It wasn't just in the home. It was the neighborhood. It was on the farm. All he ever saw was violence. And how did that impact what happened that day? Well, during those weeks prior to the incident, he was very depressed. And there were witnesses who could have talked about that.
But here's something. Prior to trial, Diaz was evaluated by 3 mental health experts. Trial counsel testified they didn't seek out additional mental health experts. There's nothing in the reports they received from the pretrial experts stood out to justify obtaining more. How does, again, in comparison, I know you were here for the last case, they obtained experts, they evaluated that. They don't have an obligation to keep on trying to find experts.
They didn't need more. The fact that I put on different experts, they did not need more. Dr. Kling reported sexual abuse in his report. All the trial attorney had to do was ask about it.
Are you saying that the decision was deficient in not putting one of those experts on?
They could have either put one of those experts on.
Did you put one of them on then in your evidence?
I did. I put them all. I put all of them on. The state put Dr. Cannon on. I put on Dr. Crowell, who would have testified. Now, the trial attorney said, well, he didn't. What they were looking for was this defense of insanity, and they didn't connect the two, the first part and the second part. And I think that's what this court asked. We have the prejudice because of the information that wasn't presented about the childhood, the pornography room, the sexual abuse, the low IQ, the migrant farm work, the structural violence. But we also have the failure to attack the mitigators. And they knew that they needed to deal with the CCP. And I think there's an interplay.
You mean failure to attack the aggravators?
I'm sorry. Correct. Yes, Your Honor. They didn't attack the aggravators. There's an interplay between the aggravator of CCP and the mental health mitigators, where you have this cold, calculated, premeditated intent, as this court found, transferred to Charles Shaw, coupled with his emotional disturbance and his inability to conform his conduct to the requirements of the law. They both said that they knew that CCP was an important issue, but they didn't work together. They said, well, we're gonna try to find some type of a mental health defense. And they could do insanity. That's perfectly reasonable to do an insanity defense, even though it maybe didn't really fit in this case, but only if you tie it in to the penalty phase. It's like there's a reasonable strategy to do kind of like a double penalty phase, where you present a mental health defense that even though you know your client's going to be found guilty, that you're trying to either go for that second-degree murder, but the jury wasn't told the secret.
Could you explain the issue of that there were school and medical records?
Yes.
But it was in someone else's file?
Correct.
And the trial counsel never bothered to get those records? Right. Explain how that happened.
Ken Garber is an experienced lawyer, a public defender, I think, for 30 years, and he methodically went through and began a social history. What was in his file were school records that indicated that his client was a migrant student.
Okay, well, you're in rebuttal, so just quickly. He then was he was no longer in the case at a certain point?
Right, but what was in his, and he gave them to discovery, but his work product he didn't copy for them. He wrote a letter.
And the lawyers never bothered to get this information?
Yes, there's testimony.
I mean, I'd start with that one, which seems pretty incredible.
There's testimony that they never went to his office. They never got copies of this. It's not just that they didn't get the school records. They didn't even. The prior attorney did get the school records and they never bothered to get it.
But he said he didn't get them because he didn't think they'd be helpful. But I'm trying to understand.
Well, under the ABA guidelines,
you're saying there's helpful information in the school records?
That he was a migrant student, which would have triggered a reasonable attorney to look into whether that impacted Juel Diaz, and that he failed 2 grades, and that he had. Well, there was a poor performance. It wasn't a low IQ, but the very poor school records.
What were the IQ in the school records?
He did not have a prior IQ test.
But your IQ testing is showing what?
57, which I think is low. It might have been impacted by depression.
Isn't that the one with the trial judge refused to follow for
Yes, for the purposes of mental
deficiencies?
retardation.
Okay, well, that's what I thought.
But
when you say you think it's low, you think it's inaccurate.
I think there was some testimony that depression may have suppressed the score. He also, Dr.
But what's
Harvey,
the reliable IQ?
There was a prior WASI of 77 and a prior WASI of 86.
So that
somewhere
would
in that
put him
range.
in what?
Close to mild mental retardation range.
And they characterize him at trial as what?
Average. And he also, in the neuropsychological testing, performed in the lower 1 to 2% range on some factors that impacted his brain, his impulse control, and the crime. Before I sit down on the juror issue, I just want to say one thing. I think it's a totality of the circumstances test. The cases cited by the state and the trial court talk about kind of black letter law. The jurors would never directly ask the question, have you ever been arrested? But I think if you look under Bernal v. Lip and De La Rosa, you really look at all of the circumstances, what was being asked, and the perspective of the juror. So that's all I wanted to say about that. Here, the trial attorneys did not do a reasonable investigation. They didn't get what was in the file. They didn't do what the standards are under the ABA guidelines, which is to get the records, the birth certificates. We know that he was born at home. And so there's no strategy. We don't get to strategy when there wasn't a reasonable investigation. And with that, I will use the remaining time for rebuttal. Thank you.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the State of Florida. The trial court's order in this case is supported by competent substantial evidence that denying his claims of ineffective assistance of counsel at the guilt and penalty phases. I'd like to clarify a little bit about what counsel was ending up with talking about there, about the file and who had the information, what have you. That Kenneth Garber was the original attorney, assistant public defender. He was on the case originally. The testimony, despite the allegations in the brief that subsequent counsel never went and looked at the file, that's incorrect. Subsequent counsel Porter testified 3 or 4 times at the evidentiary hearing that he had gotten the information from Garber's file. The only exception to that is Garber's work product, his own personal notes. Were not. Well,
wait. Let's go to the actual records. I thought the school records, the medical records, the records. My understanding is that he never copied those. Those weren't provided to him, and he didn't go and get them because he didn't think they'd be of any use. Was that not his testimony?
That was the other attorney's testimony, Neil Potter.
Well, did they have the school records or not?
They were not in their file. That does not mean he could not recall because it had been over 10 years, but they weren't in the file.
School records. Again, you got a 24-year-old. You had a crime that is, out of the norm. Out of the norm for everybody, but for this 24-year-old, clearly distraught about his girlfriend and setting out, he's going to kill her and then kill himself. I mean, just no question about that. He doesn't get to kill the girlfriend, so he goes in the house and he does this bizarre thing, a sad, tragic thing of killing her father and then sitting there and waiting for the police. What in a defense attorney's mind would be, I need to find, just as was said, everything about this defendant from birth to 24 to understand what might have caused, because there's no issue of guilt. I mean, he's there. This is like there's nothing to do about guilt except for try to do insanity. Right. To say this is a very mitigated crime. And, of course, we struck HAC, so it leaves a transferred intent CCP and the contemporaneous felony. So going back to it, what would you not do about getting school records that might show that you had a child that was marginally functioning intellectually? Well, just explain that to me.
What happened was, prior to trial, Diaz was examined by 3 mental health experts, and they had the reports of those experts that discussed his general intelligence as basically being normal.
And did they do IQ testing?
One of them did, Your Honor.
And what did that test show?
That was a WASI that came back with an 86.
So the 86, is that, we consider that basically normal?
I think that's very indicative of his scores. There was testimony that he took, the school records showed that he took this California achievement test in his elementary years from kindergarten through 5th grade or what have you. And those correlated to an IQ of like 91 up to 114. So the testimony at the evidentiary hearing from the state's expert was that there was normal academic functioning in this case, that he was capable of...
Did he fail 2 grades or not?
Yes, and according to him,
but
it was
all we're first talking, we're not talking about yet prejudice.
Right.
I'm just asking,
right.
Because one of the things throughout the time I've been here is that I never, and I think the ABA says it, you start with records. You can get experts to say, unfortunately or fortunately, just about anything. But you start with the records because sometimes the records reveal things that lead you then on the path. And for a defense lawyer to say either, I didn't think they would be helpful, is when they're already in someone's file, I don't get that. And you're saying they might have had them, but they didn't use them and they're not in the file. So I thought that the evidence was that he didn't think they were important to obtain. Is that true or not true?
That was Neil Potter's testimony. He was primarily responsible for the penalty phase. Unfortunately...
So so then that is what happened. They didn't obtain these records that were clearly in the prior defense lawyer's file. And there is information in these records that may have been helpful to use in strategizing on how you're going to present mitigation.
Well, they may have been, but I would argue that there was no prejudice, even if
well,
they
now,
had
as I said, we start with one or the other,
right.
But you were starting with no deficiency.
Well,
and
I was trying to clarify the file situation because Neil Potter did testify about that. He was primarily the penalty phase. The guilt phase attorney, Porter, testified in detail about this at the evidentiary hearing. Neil Potter never really testified much. All his testimony was I can't recall if I talked to Garber.
But this is all this not recalling stuff, which I understand happens. But when the penalty phase lawyer, who's responsible for it, says, I didn't get it because I didn't think it was important, and the guilt phase lawyer, we were supposed to have 2 lawyers in there, so you have a coordinated conduct, okay? It says, let's look at the school records. And the other part, I do not understand, and explain it to me, how when you have you mounted an insanity defense, did they mount an insanity? Yes. Okay, because that's the only defense.
Right.
Then were they carrying over whatever was the failed insanity defense into
the penalty phase?
The penalty phase. So what was put on by them in the penalty phase?
The only live testimony at the penalty phase was the sister and Juel Diaz himself. And they relied on the guilt phase because they had actually introduced the reports from Dr. Kling and the state's expert, Dr. Keown, in evidence at the guilt phase.
And I guess my problem with that is that, again, you've got a situation, you failed on showing he's insane, and that was what you were saying. So the issue for insanity is very different than the issue for mental health mitigation. What was their reasoning? Well, after they lost on insanity, they know they've conceded guilt, essentially, by saying that's what you have to do, right, for insanity, that he did it, but he wasn't capable. So it's not a question of, listen, this guy did it. Now we have to examine what would make a distraught boyfriend try to kill his girlfriend and then kill the father. So how do you not put on credible mental health testimony? Where's the downside on it?
Well, Your Honor, they did present it at the guilt phase, but they didn't recall them at the penalty phase.
But that's what I'm saying to you. When you present it in the guilt phase, though, you're presenting it for a different reason. Well, I understand they said that. Was their reason that we thought they would remember what was in the guilt? Is that what they said?
No, Your Honor. What they said was twofold. One is that their client didn't really like that kind of evidence presented, and he was hampering their he didn't want that presented. He didn't want them investigating that aspect. And the other thing was they had the reports. There just wasn't that much in them to present. Basically, the report shows that he has anger issues and he was depressed, and that's pretty much the gist of all the mental mitigation in this case is that he has severe anger issues, and that was presented to the jury.
How do you think, you don't think that a history of, from the point of when he was born up until his life there, that what was reported or recorded by Ms. Eckert in her argument might be very powerful?
No, that would not have gone over well with the jury, Your Honor, because it wasn't actually factually correct, first of all. He was not a migrant farm worker's child. He grew up in the city of Fort Myers in a residential area. He lived in low-income housing projects at some point in time, but he also lived in a home. But the testimony is very vague as to what he did himself. I will grant that his mother was apparently a migrant farm worker from Texas, and that they moved here when Diaz was about 5.
Was there violence in the house?
Yes, and that was presented.
That he witnessed?
Yes.
That was presented through the
sister.
Okay, but don't you need an expert to explain how the cycle of violence influences a child as they become an adult in terms of how they deal with relationships?
Right. Well, some of that did come out in the guilt phase, Your Honor, and it was certainly in the report. So the jury was aware of that.
Do you think that having it in a report, that then the jury is just going to know to read the report and make their decision on mitigation?
Well, it's presented there for their availability, but it was presented at the guilt phase. That was their whole, that he grew up in this violence and that he had this anger issue.
But there was you're saying there was expert testimony,
right,
concerning that. So it's not just in the report, but the expert is actually testifying
Correct.
about that, and that's being presented in live expert testimony to the jury.
Correct, Your Honor. That came out at the guilt phase. And
I guess the problem is when the jury has rejected insanity, to decide then to say, well, even though you didn't believe him on this, let's re-explain this, I just think is